over the weekend prepared a written note so that I could keep my time limit. I've handed over, my lord, a copy of the submission. Lord, I'm now going to combine the point relating to Article 74, 163(1) and 200. That's the way in which, my lord, I'm progressing. It also deals with 361, so your lordships will appreciate how all answers are actually found in the various judgments of this court. That's my submission. My lord, the first part is India's constitution envisages a parliamentary democracy with a cabinet form of government. In India's democratic republic, ultimate sovereignty lies with the people. Parliamentary democracy, as adopted by the framers of our constitution, is the embodiment of the collective will expressed through the legislature. The executive emerges from the legislature and is accountable to it. The executive exists by virtue of the confidence of the elected house and is answerable to it. This constant chain of accountability ensures that governance is never severed from popular consent. The ultimate responsibility to make law lies with the Parliament and the state legislatures. The executive government is responsible to Parliament in the case of union and to the state legislature in the case of the states. The President and Governor are therefore titular heads bound by the aid and advice of the Council of Ministers of the Union and the states as the case may be. This fundamental understanding of the Constitution of India is evident from several decisions of the Supreme Court. Now, my lord, I have actually lifted this from different paras in Shamsher Singh, and your lordships will find they will have a bearing on 200. That is why, my lord, I extracted specific sentences.
They will have bearing on?
My lord, on 200. What is the meaning of the word governor and what is his function under 200? And what is the meaning of the word declare in 200? In Shamsher Singh, this court held that the president and the governors are constitutional heads of the union and the states, respectively. In order to be accountable to the will of the people, they must perform their functions on the aid and advice of their Council of Ministers. Speaking for the majority, Chief Justice Ray held, under the cabinet system of government as embodied in our Constitution, the President and the governors are constitutional or formal heads of the Union, states who exercise their powers and functions on the aid and advice of their Council of Ministers. The powers of the President and the Governor are similar to the powers of the Crown under the British parliamentary system. Responsibility for the Crown's actions is borne by advisers who have the confidence of the legislature, which in turn has the confidence of the people. Article 361 grants immunity to the President and the Governor, preventing them from being sued for executive actions of the government. The reason is that neither the President nor the Governor exercise executive functions individually or personally. While the executive power of a state may be vested in the governor, this power is actually carried out and exercised by ministers, elected members of the executive, under the rules of business made under Article 166(3). These rules are also formulated on ministerial advice. The view expressed in the state of UP versus Baburam Upadhyay that the power of the governor to dismiss a public servant could not be delegated was no longer good law. Following the judgment in Motiram Baker, it was clear that such a power could be delegated subject to the provisions of Article 311. This distinction made in Jayantilal Shodhan between executive functions of the Union and functions of the President did not lead to the conclusion that the President enjoyed any discretionary power. Whether functions exercised by the President are functions of the Union or functions of the President, they have equally to be exercised with the advice of the Council of Ministers. The same is true for the functions of the government. Wherever the Constitution requires the satisfaction of the President or the Governor for the exercise of any power, The satisfaction required is not the personal satisfaction of the President or the Governor. It is the satisfaction of the Council of Ministers on whose aid and advice the President and the Governor exercise their functions. Thus, the decision in Sardarilal versus Union, which held that the President had to be personally satisfied before acting under Clause C of the proviso to Article 311(2), did not lay down the law correctly. Unlike Article 74, Article 163 expressly recognized that the Governor could perform some of his functions in his discretion. Provisions that enable the Governor to act in his discretion relate to the Governor's special responsibilities in respect of Nagaland under 371A and his responsibilities under Para 9(2) of the 6th Schedule. Governors may also act in their discretion while making a report to the President under Clause 1 of Article 356 and while reserving bills covered by the second proviso to Article 200 for the President's consideration. The Governor is required to pursue such courses as are not detrimental to the state. The Constitution does not aim at providing a parallel administration within the state by allowing the Governor to go against the advice of the Council of Ministers. Justice Krishnaya authored a concurring opinion on behalf of himself and Justice Bhagwati. They held that the question before the court was whether, under the Constitution, the President and Governors were real repositories of power, or whether they played a role similar to the British Crown. The judges also expressed their surprise at the extreme views that had been advanced in support of a greater role for the President under the Constitution. My Lord, the Union of India has done this in this case. That is why, my Lord, I'm making this submission. The learned judges referred extensively to speeches in the Constituent Assembly that highlighted the establishment of a parliamentary system where power was exercised by ministers. In particular, they referred to a speech by Sir Alladi Krishnaswamy Iyer, who argued that a president who did not heed the advice of his ministers would be thwarting the will of Parliament for which he could be impeached. The argument that the President's oath of office may require him to act in his discretion was rejected. My Lord, I'm referring to this for the reason, if your lordships have seen the submissions of the Union carefully, there is a reference to an excerpt from Sirvai with reference to the oath of office administered to a president. That's why, my Lord, I'm reading this carefully. The argument that the President's oath of office may require him to act in his discretion was rejected. It was held that the President would not be defending the Constitution by denying the essence of cabinet responsibility. He would be subverting it that way. The expression aid and advise were terms of art. They meant that in a cabinet system, the aider acts and the advisor decides in his own authority and not subject to the power of the President to accept or reject such an action or decision. In respect of all the Governor's constitutional functions, it was the ministers who acted. It was only in the narrow area specifically marked out for discretionary exercise by the Constitution that the Governor was not bound by ministerial advice. Having discussed the functions of the Governor under the Constitution, including those under Article 200, the learned judges concluded that expanding the scope of the judgment in Sardarilal to enable the Governor to exercise discretion in respect of all his functions would make national elections a numerical exercise in expensive futility. A diarchy would be established with two parallel authorities exercising powers of governance. Now, my Lord, I come straight to the text of Article 74, both pre-amendment and post-amendment. In the Constitution as originally enacted, Article 74(1) stood as under, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. This court in Shamsher Singh examined the role of the President in the context of Article 74(1) as reproduced above. The court's judgment was delivered on 23rd August 1974. Subsequently, Clause 1 of Article 74 was amended by the Constitution 42nd Amendment Act 76. Following the amendment, which came into force on January 3, 1977, Article 74(1) provided there shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. The amendment thus made it obligatory for the President to follow the advice of his ministers. By doing so, it endorsed the judgment of this court in Shamsher Singh. In this regard, the observations of this court in S.P. Gupta may be borne in mind. It is clear that the President is a constitutional head and is bound to act on the aid and advice of the Council of Ministers. This was the position even before the amendment of Clause 1 of Article 74 by the Constitution 42nd Amendment Act, but the position has been made absolutely explicit by the amendment. What was judicially interpreted even under the unamended Article 74(1) has now been given parliamentary recognition by this constitutional amendment. Article 74(1) was amended further by the Constitution 44th Amendment Act 1978, which came into force on 20th June 1979. A proviso was inserted to the provision to enable the President to require the Council of Ministers to reconsider its advice once. Article 74(1), and the proviso, I read the proviso, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. Now, my lord, I deal with this MP Special Police Establishment case. The case of MP Special Police Establishment was dealing with the question of whether previous sanction required under Section 197 of the CRPC for prosecuting ministers under Sections 13(1)(d) and 13(2) of the Prevention of Corruption Act 1988, read with Section 120(b) of the IPC, would be accorded by the Governor on the binding aid and advice of the Council of Ministers. The case did not involve the Governor's functions under the Constitution. The exercise of his discretion was not governed by Article 163(1) of the Constitution. As such, the observations of the court were limited to the facts and circumstances of that case, and the observations made in the context of Article 163 ought to be interpreted in its proper context. It is also important to note that at para 12 in the MP Special Police Establishment, this court inadvertently referred to para 154 of Shamsher Singh as declaring the law laid down in that case. It is important to clarify that the said paragraph forms a part of Justice Krishna Iyer's concurring opinion. The majority judgment in Shamsher Singh is in paras 1 to 90 of the report, Ray CJ, writing on behalf of himself and Justices Palekar, Matthew, Chandrachud, and Alagiri Swami. This inadvertently quoted para 154 of Shamsher Singh led to the observation in MP Madhya Pradesh Police Special Establishment that discretion may be available to governors where situations bring about a peril to democracy. Such a conclusion is not supported by the majority opinion in Shamsher Singh. In fact, it is respectfully submitted that any unfettered discretion conferred upon a governor can severely endanger our democratic republic. I then come along to the next judgment, which is Dr. Chauhan's judgment in Justice R.A. Mehta's case, State of Gujarat versus R.A. Mehta. It is submitted that the judgment of this court in R.A. Mehta has correctly laid down that governors must act on the aid and advice of the Council of Ministers, save in a few well-known exceptional situations. This court also correctly identified the functions governors perform on the aid and advice of their Council of Ministers. Notably, these functions included giving assent to bills or withholding assent under Article 200. The court held, however, the power to grant pardon or to remit sentence, the power to make appointments, including that of the Chief Minister, the Advocate General, the district judges, the members of the Public Service Commission, are in the category where the governor is bound to act in the aid and advice of the Council of Ministers. Likewise, the power to prorogue either House of Legislature or to dissolve the Legislative Assembly the right to address or send messages to the houses of the legislature, the power to assent to bills or withhold such assent, the power to make recommendations for demands of grants, and the duty to cause to be laid for every year the annual budget, the power to promulgate ordinances during the recess of the legislature, also belong to this species of power. Again, the obligation to make available to the Election Commission requisite staff for discharging functions conferred upon it by Article 324(1) and Article 324(6), the power to nominate a member of the Anglo-Indian community to the Assembly in certain situations, the power to authorize the use of Hindi in proceedings in the High Court, are illustrative of the functions of the governor qua the governor, which means, my lord, on aid and advice. Now, my lord, we come to these words in 163(1), by or under the Constitution, because by must mean something, under must mean something else. Now, my lord, please see para 18. Under Article 163(1) of the Constitution, governors are to exercise their functions on ministerial advice, except insofar as they are, by or under this Constitution, required to exercise their functions in their discretion. It is respectfully submitted that the Constituent Assembly's decision to retain insofar he is, by or under this Constitution, required to exercise his functions or any of them in his discretion, in Article 163 was meant to serve as a safeguard, ensuring that the governor's discretion is confined only to situations explicitly specified in the Constitution. Dr. Ambedkar clarified that it was not a general clause giving the governor power to disregard the advice of his ministers in any matter in which he finds he ought to disregard. Similarly, in the debates regarding the mode of appointment of a governor, under Article 155, Dr. Ambedkar remarked that any method of appointment did not change the purely ornamental role of the governor, since he was bound to act and aid and advise of the Council of Ministers in all matters under the Constitution. In sharp contrast with this understanding of Dr. Ambedkar, it has been contended by the Union that the Constituent Assembly debates indicate that the governor was, by virtue of holding the highest constitutional office in the state, empowered to exercise his discretion independent of the aid and advice of the Council of Ministers. It is submitted that the governor is empowered to act in his discretion by the Constitution, where a provision of the Constitution expressly enables him to do so. The expression under this Constitution refers to specific provisions of the Constitution that empower the President to enable the governor to act. So, my lord, like a 356(1) proclamation, then the President directs the governor to act as his delegate. It's in respect of this. A governor, now, my lord, by the Constitution, I have set out all the relevant articles. Under the Constitution is Article 356(1)(c), 371, and 371(c). Well, 356(1)(c) is when a state is placed under President's rule, the President allocates under ancillary and consequential provisions, well, 356(1)(c), specific powers to the governor to act as delegate. Likewise, my lord, in respect of Maharashtra and Gujarat in certain specific areas like Kolhapur or Kutch, my lord, Article 371 says President by order can direct the governor. Similarly, my lord, Article 371(c). So in those cases, it becomes under the Constitution. In the other cases, it is by the Constitution. Now, para 22, my lord. A governor may also be required to perform functions under a statute. In such cases, the source of the governor's powers is the statutory provision itself and not Article 163(1) of the Constitution. Where the Constitution contemplates discharge of functions under a statute, it does so expressly. For example, Article 76(2) requires the Attorney General to discharge functions conferred by or under this Constitution or any other law. exercising discretion under a statute is consistent with the oath of a governor under Article 159, which obligates him to not only defend the Constitution, but also the law. Illustrative examples of statutory functions include the grant of sanction to prosecute a public servant under the now repealed Section 197 of the Code of Criminal Procedure, or the exercise of statutory functions by the governor in his capacity as chancellor of a university, or the exercise of statutory functions by the governor in his capacity as the ex officio chairman of a shrine board. In view of the above, the suggestion at para 49 of the judgment in Justice Mehta that the words under the Constitution also cover functions that governors perform under statutes may not be correct. Well, I thought I should clarify where it lays down the law consistently that one sentence, my lord, may not be correct because they are statutes of the legislature.
According to you, under 197 of CRPC, it's the governor's discretion.
Well, under 197, it's a statutory because it's
statutory, but then whether they are also
in his discretion.
Because he's not required to act on the aid and advice of the.
No, not on 197, not for sanction. Well, this is held in two judgments, not only MP establishment. Before this, we had Ramdas Naik versus Antule. There also, my lord, your lordship said he acts independently of the aid and advice of the Council of Ministers. But that's a statutory function. My lord, Mata Vaishnav Devi Shrine Board, your lordship said, if he is mentioned, he acts independently. He does not take aid and advice. He is a chancellor of a university. Please.
Has any judgment considered the scope of sub-article 2 of 163?
My lord, on 163.2, I must tell you, lordships, there are two judgments. I'm glad your lordships asked me. I thought I must straight away answer it. 166.3.2, my lord, Justice Variava has placed a lot of emphasis on 163.2. But, my lord, there is another opinion, which is in the Nebia case, where they say 163.2 is not the investment or investiture of power or discretion. It's only 163.1. Justice Variava thinks it's 163.2.
Well,
that's all, man. These are the two.
But the reason why I'm asking you
Please,
is
certainly.
If we take that line that the powers are only those which are crystallized in the Constitution, identified in specific provisions of the Constitution, then in which case empowering or declaring, rather, it's not an empowering, it's a declaration in sub-article 2, which says that that discretion is finalized. So therefore, there is the scope for, the Constitution recognizes the scope for the governor to come to a conclusion that this is in his discretion, and that decision making is given a finality. That's the purpose of sub-article 2, which means that the process of identification is not so much crystallized in specified articles, but there is a process by which he would identify, and this identification is declared to be final.
That I respectfully urge your lordship to take a contrary view, because, well, that would mean in all places where he acts on aid and advice, he may then claim discretion. This is a danger. Lord, I'm making your lordships alive to the possible outcome of this interpretation under 163.2. If it was a standalone provision, Lord, it might be different. But it is in the context of 163.1. That is why the words are by or under the Constitution. And Manoj, this is what Nebia correctly interprets, that 163.1 alone is relevant. 163.2 does not give a source of power.
It is blank.
Now, Manoj, please come to para 24. That the expression under this Constitution does not extend to legislation is also clear from an examination of other provisions of the Constitution. For example, Article 165(2) refers to functions conferred on the Advocate General for a state by or under this Constitution or any other law for the time being in force. Similarly, Article 173(c), which deals with qualifications for membership in the state legislature, speaks of qualifications prescribed by or under any law made by Parliament. The words "under this Constitution" cannot therefore extend to other laws, including statutes. This is the. It is submitted that the judgment in Nabam Rebia has correctly laid down that the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature. This court, my Lord, may I take your lordships to that para if it's needed, because that answers my Lord, the Honorable Justice Narasimha's question. My Lord, please take volume Roman 5, 22. My Lord, it would be just, yeah, thank you. Please go, my Lord, to volume 5, V22. Just one para, my Lord, in the judgment.
This one.
My Lord, at page 8618, printed page 8618, para 148.
Para 148.
Yes.
We already marked that.
Yes. My Lord, this is with reference to my Lord Justice Narasimha's question. The above, sorry.
আচ্ছা দেখুন আজ হচ্ছে আপনার
The above position leaves no room for any doubt
কনস্টিটিউশনাল
that the governor
বেঞ্চ
cannot
চলছে
be seen to have such powers and functions
আজ আপনার
as
হিয়ারিং
would
হওয়ার সম্ভাবনা খুব কম
assign to him a dominating position over the state executive
তো
and the
দেখা
state
যাক।
legislature. The interpretation placed in Article
কতক্ষণ চলে?
163(2) on behalf of the respondents has just that effect, because the following
তো
contentions
3 নম্বরে না 4 নম্বরে আছে
advanced
ওবিসি
on
কেসটা
behalf
3
of
4
the
নম্বরে আছে
respondents.
মেইন কজ লিস্টে
Firstly,
হতে
whenever
পারে
a
ঠিক
question
আছে ওটা হবে না বলে
arises,
ভুল এটা ভুল কথা হতে
whether
পারে
in discharging a particular function, the governor can or cannot act in his own discretion, according to the respondents, the discretion of the governor on the above question
দেখতে
is
থাকুন অবশ্যই
final.
হবে
Secondly, since the provision itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondents, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above position will convert the governor into an all-pervading super-constitutional authority. This position is not acceptable because on examination of the executive and legislative functions of the governor from the surrounding provisions of the Constitution clearly brings out that the governor has not been assigned any significant role either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellants, on the other hand, augurs well in an overall harmonious construction of the provisions of the Constitution. Even on a cursory examination of the relevant provisions of the Constitution, we are inclined to accept the contention advanced on behalf of the appellants. My Lord, I'm grateful to my learned friend. My Lord, at para 149, if your Lordship sees at the bottom.
Refer to the constitutional debates.
Yes, the Constituent Assembly debates. Your Lordships have seen. It's Now, my lord, let me return to my note. Please come to para 27. Para 27, my lord. Additionally, governors are also empowered to act in their discretion where such intent emerges from a legitimate interpretation of the provision concerned, and the same cannot be construed otherwise. It is submitted that the governor's power to act in his discretion under 356(1) and the second proviso to Article 200 would fall under this category. But I've already referred to para 147. Now, please come to 29. Keeping in mind the emphasis of the court in Nabham on the very limited role of the governor, this court's endorsement of the report of Justice Punchi Commission was only to the extent that it cautioned against the grant of wide discretionary powers to the governor at the expense of the real executive, namely the Council of Ministers. Now, my lord, I have taken the submissions so that your lordship see, and my lord, I say so with great respect to the learned Solicitor General. My lord, he argued this case with extraordinary industry. I say so with great respect. It is respectfully submitted that there is a divergence between the submissions made by the learned Solicitor General on behalf of the Union and the law as laid down by this court. This divergence is being pointed out to assist this court and not based on any instructions. In respect of the role of the President, the written submissions of the learned Solicitor General contend, relying selectively on the writings of H.M. Sirbai, it is suggested that the President of India may in certain circumstances in his discretion dismiss the Prime Minister and the Union Council of Ministers or dissolve the Lok Sabha. It was contended that these powers also extend to the governors. That the President may in his own wisdom determine whether to assent to a bill reserved by the governor for his consideration. That the President may act in his discretion in making a reference to this court under Article 143. It is stated that the President, if he so wishes, can always in his discretion further refer the matter to the Supreme Court for its own opinion. That the President and the governors ensure that both the central and state governments operate within the parameters set by the Constitution, balancing autonomy with oversight correctly reflect the law as laid down by this court in Shamsher Singh. They are also contrary to the express words of Article 74(1) of the Constitution. It is submitted that the President of India, who is a constitutional or formal head of the Union, must perform his functions on the advice of his Council of Ministers. While the proviso to Article 74(1) enables the President to require the Council to reconsider its advice once, he is obligated to act in accordance with the advice tendered after such reconsideration. The President is not empowered to act in his discretion while making a reference to this Honorable Court under Article 143. In any case, there is absolutely no question of the President in his discretion dismissing the Prime Minister, other ministers, or dissolving the Lok Sabha. Any such construction.
That is not his argument. He says that
No, my lord, I have gone by his written submissions.
Yes.
I want your lord.
So
to
President
is bound by the aid and advice.
insofar as President is
my lord, I only went through his.
the learned solicitor distinguishes President and Governor. According to him, the President is bound by the aid and advice of the Cabinet,
My lord,
not the Governor.
My lord, I have taken an effort to read the submissions. Whichever portions are not consistent, I'm just pointing it out. And my lord, I'm doing it with a great deal of deference, respect, and admiration for the learned Solicitor General. But my lord, it's my duty just point out so that it's accurate. That's all. My lord, if you think there is an error in his submission, you must attribute it to me. I'm senior to him. You must attribute it to me. I must be the one to take it on my shoulders. My lord, these are some privileges. I hope the Solicitor General doesn't take.
No. Okay, right.
My lord, please come to para 35.
You are not as friendly to him as Dr. Singhvi and Mr. Kapil Sibal.
I don't know who's more honest. I don't know who's more honest.
We can't answer that.
As far as the role of the governor is concerned, the union has submitted that the governor acts as a representative of the president and exercises executive powers of the state on behalf of the president. However, it is also submitted that the governor discharges his duties as a statesman, unaffected by the political composition at the center or in the state concerned. That the governor is the agent of the center who will guard the center's policy. This contention is based on a speech in the Constituent Assembly. That the governor's power to summon and prorogue the state legislature is a legislative power. It is suggested that these powers can be exercised by the governor in his discretion. It is submitted that the governor does not act under Article 256 and Article 257(1). Additionally, in respect of the state's power to make laws
কেসটা
under list 2,
3
the
নম্বর
states enjoy
3 নম্বরে listed
executive
আছে
and legislative
নম্বরে।
power conferred under the Constitution. The wide range of discretionary powers that are identified in respect of the governor are contrary to the judgments in Samsher Singh and Nab. Lastly, it may be noted that the union's submissions have the effect of resurrecting this court's judgment in Sardar Lal, which was unanimously overruled in Samsher Singh. The Union of India
আচ্ছা,
has
যাই
highlighted
হোক,
the functions
আমি
governors perform under Articles
আপনাদের
154,
লাইভ থেকে বেরিয়ে যাচ্ছি, ঠিক আছে?
163 to
লাইভ থেকে বেরিয়ে
167,
যাচ্ছি। আপনাদের
165,
ওবিসি
233, 234,
যখনই
316,
ওবিসি
Kamal,
লাইভ
I've
যখনই
referred
শুরু
to all
হবে
of them.
তখনই
These
আপনারা
are
এই চ্যানেল থেকে
referred
দেখতে
in the
পারবেন।
written submissions.
আবারও
In
বলছি,
the
শুধু শুধু
context
এই
of these provisions, it has been argued
আপনার কনস্টিটিউশনাল যেসব
while
বেঞ্চ
these
চলছে এসব শুনে কোনো
functions
লাভ
may
নেই,
sometimes
এসব শুনে
be
আপনাদের কোনো
formal
দরকার নেই আপাতত।
and
তো এখন শুধু শুধু দেখে
and
সময় নষ্ট
rooted
করতে হবে না,
in aid
পড়াশোনা করুন
and
বা কোনো কাজ
advice,
করুন।
some
লাইভ আসলেই আমি আপনাদের
discretion is key to
নোটিফিকেশন দিয়ে
protect
দেবো এবং সেখান থেকে সরাসরি লাইভে দেখতে
constitutional
পারবেন, ঠিক আছে?
governance, federal
তো
balance,
শুরু হলে আমি লাইভে চলে যাব,
vulnerable regions and groups,
যখনই
and the
শুরু হবে তখনই লাইভ চলে যাব,
continuity of the state.
ঠিক আছে? তো ভিডিওটা এখানে শেষ করছি,
Well, now, this is
এসব আর
what
শুনতে
I'm
হবে না।
saying is not accurate.
না কি বলেন?
In other words, it is contended without foundation that
আপনাদের
governors
মতামত কি?
may
চলবে?
possess
এটা কি
discretion
চলবে
in
নাকি?
appointing the Advocate General, summoning the state legislature, addressing the houses, making a special address to that legislature, assenting to bills, making decisions concerning the disqualification of members, the laying of the annual budget, and appointing district judges, appointing members of the governor has enough discretion to effectively veto a bill by simply withholding a bill without returning the bill to the House for reconsideration under Article 200. Based on the law laid down in Samsher Singh, it is respectfully submitted that this argument of the union in support of an absolute power to veto will render the state elections completely futile. These submissions are contrary to the letter and spirit of the Constitution. Now, my lord, I come to 200. The Constituent Assembly debates firmly demonstrate that the founders intended the governor to only be a titular head acting on ministerial advice. Article 200 was derived from Section 75 of the Government of India Act 1935. However, unlike Section 75, which gave the governor express discretion to assent, withhold or reserve a bill, the expression in his discretion was deliberately omitted from Article 200. Dr. Ambedkar in the Constituent Assembly debates on 31st May 1949 had clarified that the role of the governor was purely ornamental. My lord, I must say, with respect, I truly admire the industry of the learned Solicitor General. He put Government of India Act 1990, then he put 35, then he put the Rao Committee, the drafting committee. But my lord, this is a new constitution. It is a break from the Government of India Act 35. So the discretion which is enjoyed under the 1919 Act or the 1935 Act must not actually creep into the interpretation of the Constitution. Then, my lord, para 45. The governor is not conferred with any discretion by or under the Constitution in relation to Article 200. Under Article 200, the governor is bound to act in accordance with ministerial advice, b. withhold assent for the purpose of returning a bill to the House or Houses for reconsideration, or reserve a bill for the President's consideration. The sole exception is found in the second proviso to Article 200, which entitles the governor to exercise discretion in reserve powers of the High Court as to endanger its constitutional position. Now, my lord, the next point is whether this power to assent is a legislative power. Assent by the governor under Article 200 is not a legislative power. The governor is a part of the state legislature under Article 168. However, the assent of the governor under Article 200 is not a legislative power. The act of assent is also quintessentially an exercise of executive powers of the state, which could have characteristics of a legislative act. My lord, he is the head of the executive. So he also acts as the head to declare a bill to be a law. My lord, that declaration in Article 200 is to declare. My lord, what do we mean by law declared by the court? A bill is declared to be a law by the assent of the governor. Chapter 4 of the Constitution specifically provides for the legislative power of the governor. The sole provision under this chapter is Article 213 relating to the power to promulgate an ordinance. Pertinently, even the legislative power to promulgate ordinances is exercised on the aid and advice of the Council of Ministers. The 7-judge bench in Samshay Singh clarified that all other powers of the governor are executive powers, even if they partake of legislative or judicial actions. Articles 200, 201 fall under the subheading of legislative procedure under Chapter 3. A bill needs to be approved by all components of the state legislature to have the force of law. Since all executive power of the state is vested in the governor, under Article 154, the governor's assent represents his imprimatur and certification on aid and advice in relation to a bill passed by the legislature. Even though governors are a part of the legislature, Article 158(1) expressly precludes them from being a member of the House. They are not entitled to participate in the proceedings and affairs of the House. They do not have a right to vote or participate in deliberations. The right of the governor to address and send messages to the House under Articles 175 and 176 are exercised only on the aid and advice of the Council of Ministers. Similarly, the governor's powers under Article 202(1) and 207(1) are also exercised on ministerial advice. This unique relationship between the governor and the legislature has been explained in Valluri Basavaya and State of Bihar versus Kameshwar Singh. Thus, while the governor's assent under Article 200 forms a part of the legislative procedure, it does not constitute legislative power that may be exercised independent of ministerial advice. It is therefore most respectfully submitted that the submission of the Union that Article 200 confers a legislative power upon the governor is liable to be rejected. The text of Article 200 makes it evident that the governor must follow one of three courses of action. It is no longer res integra that a governor must exercise one of only three courses of action under Article 200 under the aid and advice of the Council of Ministers: grant assent or withhold assent for the purpose of returning a bill to the House as soon as possible for reconsideration, and if the bill is passed again by the House, the governor must grant assent or reserve a bill for the President's consideration. This Honorable Court has, on at least 5 separate occasions, held that the substantive part of Article 200 mandates that the governor shall exercise one of only 3 specified courses of action. In case of withholding of assent, the governor is bound to follow the procedure prescribed under the first proviso and assent to the bill if it is ultimately presented to him after reconsideration by the legislature. My lord, there was some emphasis on the words that the governor shall declare. But my lord, that declaration does not have an independent meaning in that article. Declare means you do one of these 3. It is a form of action. The word declare, my lord, is a form of action. One of the 3. Assent the bill, that's also a declaration. Return it to the House for reconsideration, also a declaration. Reserve it for consideration of the President, also a declaration. So there are no 2 separate acts in 200.
It only excludes
Pardon?
the pocket veto.
Yes.
It excludes the pocket veto.
That's right.
because there's no declaration.
That's right.
You just put it in your pocket and sleep.
That's right. In any case, the only 3 courses of action under 200 are based on the binding aid and advice of the Council of Ministers. My lord, I must, in fairness, point out that, my lord, even though Chief Justice Ray took the view that the second proviso to Article 200 conferred a discretion on the governor, Justice A.P. Sen in Valluri Basavaya Chowdhury said even in that second proviso, it's on ministerial aid and advice. My lord, it might look at first blush to any reader that there's a little inconsistency in both those 2 judgments. But my lord, there's a way to harmonize both. Namely,
Current
it
চলে
is
গেছে,
possible that a cabinet
কারেন্ট চলে গেছে,
may
তো এই জন্য
also
ভিডিওটা এখানে
say
শেষ করছি।
that this does
কারেন্ট
touch
আসলে পরে
upon
আবার আমরা
the
চলে আসবো এবং
jurisdiction of a
লাইভ
high
শুরু
court.
হলেই চলে আসবো,
Please
ঠিক
send it
আছে?
to the
এখন তো ওবিসি
Which is why
হিয়ারিংটা হচ্ছে
Justice
না এখন
Sen
এখানে।
said it